que são inclusivas e que tenham objetivos além de meramente comerciais, mas que todos sabemos que, na verdade, é o objetivo de toda a atividade econômica. Então, eu acredito que vai ser muito instigante ouvir um pouco da questão jurídica relacionada às marcas famosas e as questões econômicas que levam os empresários e as empresas, no fim do dia, a tomarem decisões de realmente fazer um investimento na marca, né, para que ela se torne famosa e também que obtenha uma proteção especial e que reverta para ela não só benefícios jurídicos, né, na questão de você poder exercer uma maior proteção ao seu ativo, mas também uma reversão economicamente falando. Bom, e dito isso tudo, eu vou apresentar aqui hoje as nossas palestrantes, né? Vamos começar com a Megan Carpenter. Hi, Megan. I'll just turn to English, so you can correct me if I put something wrong.
A Megan, agora eu vou falar inglês. Se eu errar o seu currículo, ela é a reitora da universidade e também é conhecida como pessoa interessada em empreendedorismo, marcas e as artes. Ela está na área de propriedade intelectual, envolvendo a economia, o papel da lei, do empresariado, e publicou vários artigos em diferentes publicações de renome.
Megan. A Anne Grecco é diretora de estratégia da Interbrand, com mais de 15 anos de experiência em estratégia de marca, cultura e negócios, e gestão de pessoas e formação de equipes. Hoje a Anne lidera gestão e condução de projetos e pessoas com foco na evolução de culturas e identidades, além da capacitação em liderança sobre a relevância estratégica de ativos intangíveis e a transição do modelo mental da marca como uma ferramenta de marketing para a marca como um ativo estratégico do negócio. Sem maiores delongas, eu vou passar a palavra a Megan para que ela possa nos engrandecer com a sua palestra. Megan.
Muito obrigada, Samantha. É uma honra estar aqui com todos aqui presentes, e eu estou entusiasmada em falar sobre a perspectiva americana e do arcabouço legal americano em torno das marcas famosas. Os conceitos-chave dos quais vou falar têm a ver com o estabelecimento da Convenção de Paris, onde começamos com essa ideia. O que aconteceu nos Estados Unidos e como isso é tratado internamente. Vamos falar também de uma divisão das varas de circuito e da TTAB, que é o braço judiciário dessa área, e qual é a sua posição. E vou falar também de algumas proteções adicionais com as marcas famosas e hoje tendências atuais do que vemos hoje na casuística nos últimos meses. Então, as marcas famosas nos Estados Unidos têm uma doutrina complicada. E para assegurar os direitos, nós falamos do registro, que vai se tornar mais importante do que nunca. E isso não é o exigido aqui nesse artigo 6 bis da Convenção de Paris. As marcas estrangeiras não registradas nos Estados Unidos e bem conhecidas podem ser protegidas mesmo sem registro. E também, se uma marca é chamada famosa, entre aspas, sob a lei federal, tem uma barra mais alta para a sua proteção. Entretanto, empresas estrangeiras que confiam nessa doutrina, cada vez mais veem desafios e incertezas sob a lei americana. E os juízes americanos não conseguem saber o que é isso E se o PTO americano também não tem uma boa...
United States. And then I'll talk about kind of 3 practical future trends. So we know that the Paris Convention established the well-known marks doctrine and says that a trademark that's well-known in a particular country is going to be protected there even if it's unregistered or used in commerce. But the U.S. Congress has not explicitly amended the Lanham Act, which is our federal trademark law, to incorporate the doctrine. So as a result, we see disagreement among courts and the TTAB as to whether it really even exists in the U.S. And I'm going to tell you kind of both sides of the coin here. The Second Circuit and the Ninth Circuit are 2 significant areas of sort of judiciary authority in the United States. And that would be really East Coast and West Coast. It's New York and California. And New York and California often have rivalries about all kinds of things, whether it's hip-hop music, East Coast versus West Coast, or whether it's sports, and you're talking about, say, the Dodgers versus the Yankees. And so it is perhaps no surprise that the Second Circuit, which is focused in New York, has a different approach to the well-known marks doctrine than the Ninth Circuit, which is in California. So let's take the Ninth Circuit authority first. And this is about the grocery store Gigante, and very popular in Mexico. And there was an individual that set up a grocery store and called it Gigante in San Diego, California. Which is in the southwest of the United States, close to the Mexican border. There are many Mexican immigrants in that area. I think the population of San Diego is about 35% Mexican. And yet, Gigante, the Grupo Gigante, had not used the mark and had not opened any grocery stores in the San Diego area. So even though the mark was not in use, a lot of the population of the area was drawn to go to the Gigante store, even though there was no connection to the actual company. So in that case, the Ninth Circuit recognized, okay, priority of rights in the United States is based on use in commerce. And okay, trademark law is territorial. But there's an important consideration here, and that it's important to recognize that the well-known marks doctrine is an exception to that principle, and the U.S. is part of the Paris Convention. So if there's a way to interpret it to incorporate the well-known marks doctrine, that's what we should do. So the Ninth Circuit opinion focuses on consumer confusion and avoiding fraud. And so the Ninth Circuit recognized that consumers in the United States, in a significant number, recognize that trademark as having achieved a certain level of fame. And we'll talk about fame here in a little bit. So under that authority, the territoriality principle wouldn't stop protection and priority there and enable the infringement action to succeed on that basis. Okay. So essentially, here's the law in the Ninth Circuit. We've got the territoriality principle that's not going to prevent protection where there's the potential for substantial consumer confusion and fraud as well. Okay, now we're going to talk about what happened. After that, the Gigante store, it's now Eduardo's. So they were able to stop that from happening there in the Ninth Circuit. Now we're going to talk about New York. A different result, a different case. Bukhara, I'm not sure if you've been there, is an amazing restaurant that is in India, in Delhi and in Mumbai. And they had a franchise restaurant open in New York City. Unfortunately, the restaurant closed down. And after the restaurant closed and the mark was no longer in use, former employees of Bukhara in India and former employees of Bukhara in the United States combined together and created a restaurant called Bukhara Grill. The court in New York focused on that territoriality principle that we were talking about and really held very clearly that a foreign owner of a trademark can't assert priority without some kind of use in commerce. Even if the copy is intentional, even if it's knowingly. And the court noted that Congress hadn't expressly incorporated into U.S. domestic law that provision of the well-known marks doctrine from the Paris Convention. So you can see two completely different results with pretty similar facts. I'll talk a little bit about the TTAB. So the TTAB is the administrative court of the USPTO, which decides opposition proceedings and cancellation proceedings. And so in this particular case that was about the mark Solbing, the plaintiff argued that when they were attempting to oppose registration of the Solbing mark by someone else, that her mark, Solbing for frozen yogurt and desserts, was famous not just in Korea, but was famous to Korean Americans. That there's a substantial population of Korean Americans in the United States that are aware. There are a lot of people who are traveling because it's so well known in Korea, that the social media and the website engagement was international engagement on, and not just focused in Korea, and that she had filed applications for registration with the PTO. Unfortunately, she didn't file applications with the PTO until after all of this started, so that wasn't a terribly good argument. But the TTAB dismissed the action because they said simply, the well-known marks doctrine cannot serve as a basis for opposition, and that use in commerce in the U.S. is required. So you can see that there's a lack of clarity to completely opposing positions there from the Ninth Circuit and the Second Circuit, and it makes it very difficult to give practical advice to clients. So that's one component when we think about the well-known marks doctrine. I want to talk about sort of two other prongs, and those deal with famous marks. Now, famous marks and foreign marks can qualify for extra protection if they are famous. It's a higher bar than a well-known mark. I guess it's easier to be well-known than it is to be famous, and there are two ways to approach that. One is through the likelihood of confusion space, and then the other is in the dilution space. And I'll unpack that just a little bit. So first, in the likelihood of confusion space. Likelihood of confusion is the core, the sine qua non of trademark infringement. And when we look at some of the factors of likelihood of confusion in the U.S., for the USPTO, they're called the DuPont factors. So that would be for a federal action. And the fifth factor that is considered is really the fame of the mark there. Now, the fame of the mark, when it's considered in a likelihood of confusion analysis, looks really about the class of customers and the potential customers of a product or service. So not the general public. It doesn't have to be famous to everybody. It can be famous in a niche or specialized market, or among a specialized group of consumers. So basically, in this analysis, we want to know if a mark is renowned within the very specific market for those goods or those services. And we look at consumers of similar products as well. And the more famous the mark, the more likely we are to find a likelihood of confusion. Dilution's different. And as we're going to see, fame has a different kind of analysis, and it really looks at the general public. It's more all or nothing and kind of zero sum. Under the Federal Trademark Dilution Act, foreign marks can qualify for extra protection if they are famous, and that goes for domestic marks as well. And that can happen in two different ways. One, that there's a likelihood of harm in kind of a blurring sense. It harms the distinctiveness of the mark. Or it harms the reputation of the mark through something that is called tarnishment. That can be outside the class of goods and services, and it doesn't have to cause any kind of confusion. But it has to be famous not just in that specific area, it has to be famous among the entire general public. So you can imagine that is almost impossible for certain clients with certain classes of goods and services, but a very difficult goal to achieve. There are 4 different factors that we look at when we're looking at fame. And I'll contrast these some with Brazilian law. And we look at 4 things, really, the duration, the extent, the geographic reach of advertising. We also focused on sales, basically the same thing, right? The duration, the volume, the geographic reach of sales. The extent that the mark is recognized, and there what we would show are consumer surveys, market surveys, that kind of thing. And whether or not that mark is registered. And in the United States, there's no official list, there's no official registry of famous marks, like there is in many other countries, including Brazil. It's more on a case-by-case basis, and there's no particular time limit, which is another interesting component, because something that is found to be famous in one instance may eventually lose fame, lose market share, and then suddenly lose that additional protection as well. So these are all marks that have been shown, and I had to include Barbie, right? Because of the Barbie movie, it's all the rage. But you can see a variety of different, both kind of US-based and international companies. These are all on a case-by-case basis have been the subject of individual court actions where the mark has been adjudicated officially as famous. Things that have not been found famous, one was the App Store, one was Timberstone for golf. Coach was actually found, Coach for luxury goods at one point was found not famous. That's a good example to me that I think if Coach were to come back before the courts, I think we might have a different result now than we would have had about 15 years ago. So if the mark has sufficient fame, the mark owner then can potentially stop junior users from using the same or similar marks on goods and services in the US without establishing confusion. Which is interesting. So one piece of practical advice would be that owners of foreign marks should register because the application of that doctrine is uncertain. If there's use and fame, there's significantly broader protection within U.S. law. So I'll contrast this a little bit with Brazilian law and see if Samantha wants to weigh in at all here. But when we look at the 4 factors in the U.S., we're looking at 5 factors that have a slightly different approach here in Brazil. Recognition by a large portion of the Brazilian public. Also, the quality, the reputation, the prestige. That doesn't come into the analysis of fame in the U.S. at all. In fact, it could be a particularly, the reputation doesn't have to be elevated in order to seek fame. There has to be a degree of exclusivity or distinctiveness. Look at registration as well, and then the time period is going to last for 10 years as opposed to indefinite in the U.S. And I don't know, Samantha, if you want to add anything here or not. Covered it? Okay. Okay. So if you are able to get on the list in Brazil, then the traditional likelihood of confusion isn't going to be relevant. And so that can be somewhat in contrast to U.S. law. One thing that I think is important to think about here, and this spans both Brazil and the U.S., is that is the principle of specialty. When we look at the kind of specialization of markets versus the general public, recognizing that there's broad protection for goods and services, but not getting too far afield. There are lots of famous marks right now, or brands, that are getting into kind of, other unrelated goods and services, perhaps more than we used to see in the past. And this presents a challenge in Brazil to the principle of specialty. It's the same in the United States. I remember when the dilution doctrine first came about 50 years ago or so, I think it was a famous judge, I think it might have been Judge Learned Hand, said something about, in the dilution doctrine, they don't have to be the same class of goods and services, but as a steam shovel operator isn't likely to produce a lipstick or something like that. But you think, Samsung Electronics has anti-aging facial products. I mean, there are so many different cross-cutting, brands that are cross-cutting markets in interesting ways that I think these legal frameworks don't contemplate. Okay. So 3 trends to watch before I end. And I'm going to say, and these are just, I'd love to hear your thoughts when we go to Q&A about what you think the trends are, because this is certainly an evolving area of the law. First, global commerce is expanding our notion of territoriality. I mentioned in the case, the frozen yogurt case, that one of the arguments that the plaintiff made was that her social media and the interaction with her brand in a variety of digital media really spanned borders. And while something may not have been for sale in a certain area, it could have a following, could potentially have a reputation there. And I think those kinds of things are going to be more and more interesting to consider as we go forward. Also, there's an expansion of goods and services into new markets, and I'll give you an example of that here in a minute. And then I just couldn't help but think, as I'm reading about these things, about in some ways the increasing sense of nationalism or territorialism politically that I think that presents some headwinds for us as well. So I'm just going to talk about 2 cases from this year to give some examples. Abitron is a case that was just, I think it was June 29th maybe, of this year that was decided by the Supreme Court. And it was a dispute between Hetronic International, which is a U.S. manufacturer of radio remote controls that are used to operate heavy construction equipment. Abitron was a distributor. It was an Austrian company, a distributor of Hetronic products. And they decided to move from just distributor to duplicator of products. So you can see here kind of the Hetronic Nova, the Abitron Nova, the Hetronic Ergo, the Abitron Ergo. And nearly all of Abitron's sales occurred in Europe. It did make a few direct sales in the U.S. The lower court in the U.S. Had a verdict for $96 million in favor of Hetronic, because it said that even though those sales didn't take place in the U.S. primarily, there was a substantial effect on U.S. commerce. And that was an interesting standard that they came up with. The Supreme Court at the end of June reversed. And they said that the Lanham Act, our Federal Trademark Act, does not apply extraterritorially to foreign conduct, and that U.S. statutes are not going to apply extraterritorially unless Congress affirmatively and very explicitly said that the statute should apply on an extraterritorial basis, or whether the conduct that's relevant to the infringement occurred within the United States. In that case, this is how I feel about many Supreme Court cases, I always think it's going to bring enormous clarity to an area of U.S. law, and it never fails to make it murkier instead. But they didn't disappoint this time in the same way. They didn't define for us what use in commerce means, and the case is really unclear what use in commerce means. Whether it applies to resales, for example, of the product, which took place substantially in the U.S. Justice Alito said we're going to approach this in a very narrow and direct way. Justice Jackson said resales should count. They all agreed to leave it alone and let the lower court decide and sent it back on remand. It's unclear what kind of conduct we need for use in commerce, what conduct constitutes use. And that seems to me to be an important determinant relevant to global trademark strategy as we're going to advise our clients going forward. Okay, second trend related to the first is what I'll call expansion into new markets. We've touched on this a little bit, and as I was discussing the comparison between U.S. and Brazilian law earlier, but I want to raise that here with regard to an interesting case about NFTs and new forms of media. So Hermes versus Rothschild, that dispute was over Meta Birkin bags. So Hermes is a luxury fashion retailer. You all may probably are aware of kind of the bags there. The Birkin bag is one of the famous Hermes products. And this particular artist, Mason Rothschild, made NFTs based on Birkin bags that weren't realistic. So these bags don't actually exist. There is no Grinch Birkin bag, or a Mastodon Tusk Birkin bag, or Van Gogh's Starry Night, or a smiley face emoji. These were all fictional Birkin bags that he called meta Birkins. And he sold NFTs. I think they were maybe $450 a piece at first, based on these bags. In the court, Rothschild said, "These NFTs are art. This is an expression of my artistic insight." And Hermes said, "This isn't art. This is commercial. You're selling NFTs based on our products, and we're going to get into the NFT space." So the court here in the U.S. found infringement and said it wasn't art. It was really commercializing a product, and agreed with Hermes. It was a jury trial, and there wasn't much reasoning. It was kind of maddening when you look at the trial. It's a checkbox, like found infringement, dilution. I wanted more meat there on the bones. But the important thing to think about, in my mind, is these new markets and how they're going to impact when we think about the metaverse and NFTs, and how these new markets might relate to some of the principles that we've discussed, especially when we're talking about those kind of unrelated classes of goods and services. So finally, this is my third prediction. My third prediction is, and it's sort of, I didn't want to make this my third because it seems depressing, but the third prediction is really, we have seen an increase around the world of nationalism and territorialism, I think, country by country. And you can see headlines around elections and economic issues and trade, and a real rise in that kind of political approach. And so as we seek to blur the lines of global commerce and protect marks across borders, we may not be immune from some of those political headwinds. And I think that's something that we should be thinking about, and it should be in the back of our mind as we're helping to be true counselors and advisors to our client. And so while politics, in some ways are wholly outside the confines of trademark law, it does remind me that we are part of a global economy that is both political and cultural. I'll stop there, and I look forward to Q&A in a little bit. Thank you.
Thank you so much, Megan. It was interesting, and it was fascinating to hear a little bit about the U.S. law, about well-known marks, and especially famous marks, which I think there are several differences in comparison to the Brazilian system. So thank you for showing us and enlightening us with your views. Agora a gente tem a Anne.
Now we have Anne, who will talk about the economic view of the brands.
Olá, boa tarde, todos me escutam?
Good afternoon. Can you hear me? Okay. So first of all, I'd like to congratulate, and we will talk about many things that are related to what you mentioned in your presentation. So I think it will be very nice. I'll talk about a different theme, different from what you are used to. And I'll try not to be boring after lunch. Let's see if I can go on with my presentation. Yes, I'll talk about how these giant and Eduardo's, as Megan said, and famous marks gain force and generate economic value for their own businesses. Before, I'd like to explain Interbrand. If you don't know, we say we are a community, a network of some experts all over the world. We are 74 that founded this term branding. Now we have updated the branding technology because many things have changed since 1974. And we are also pioneers in evaluating the value of the brands. In 98, we started our first brand valuation. And in the year 2000, we started our first ranking of brands. We started to disseminate what is the rationale behind the value of the brands, understanding them in a bigger package, not separated by economic groups. How can we understand the value of those brands? So we are pioneers in this area too. It's interesting to follow this kind of reading we do of the market. In the last 10 years, we've noticed that the value of the intangible overcome the value of the tangible things in business. So this understanding of the brand, of the strength that the brand has to the business is more and more relevant, especially when we talk about protection of brands. What is it that is important about protection of those brands that have the intangibles overcoming the value of the tangible part of the business? We've been following throughout 22 years of this ranking of the market. We know that the strong brands overcome the value of the market. In red, the red line is what we believe are the most valuable brands. And this graph shows that those famous brands or higher value brands, they create a greater value, and they also create a buffer for when the market is going through a crisis. So as you can see, in 2008, they were able to be at a higher value. And when there is a crisis and they drop less. And they return, they come back faster than other brands. So these values that are generated over the intangible of those famous brands guarantee their long-lasting activity, especially during a crisis.
We also have a ranking in Brazil that we've been doing for 20 years. I would like to highlight some points of what happens in the ranking in Brazil. There is a trend of a profile of certain brands, the most valuable ones. The first important thing to identify is that to enter the ranking, the business must be listed. The data must be open. When we see a bank entering the bank in the ranking in 7th position, it means that the role of the brand and the strength of its brand was very high, but it was not in the ranking because the data were not open data. So the data must be open so that we can include the brand in the ranking. The second important issue in Brazil is that most of the brands belong either to the financial sector or are in the retail area. We don't have many consumer goods because we consume in Brazil, like Megan said, the consumer goods are the ones that are famous from abroad that we consume here. Those that generate value are the ones that we consume. And they must be Brazilian to be here. Otherwise, we put them in the global ranking. Also, when we talk about the first place, Itaú Bank, we are talking about billions. And Hering, at the 25th place, we are talking about millions. So this package has a big discrepancy amongst the 25 brands in terms of value generation. This combination of the 25 brands generate an economic value to the market. Since 2010, it doesn't matter if we went through a market crisis or not, the valuable brands went on going up, most of them. So what is the asset? What is the asset that you have of a strong brand when we go through turbulent times? So the ascension here, the going up, is very important in this graph. It shows how much those brands are able to create that security buffer that I talked about. Within the crisis, they drop, but they recuperate much quicker than other brands. But let's understand how the brands generate an economic value to the business. What is the formula that they have to bring value to the business? First, we have to understand that they direct a choice. When a brand is able to direct the choice of the consumer, it increases its revenue. So to direct the choice, it means within your competitors, you end up to choosing one brand because of the brand. If I have this direction of choice, I generate income. Number two, those brands also have a premium price. If they have a high value, if they are strong vis-a-vis their competitors, the brand is able to be more profitable because they have a premium price. And the third point is that they generate loyalty. When the brand generates loyalty, it reduces the risks. It creates a margin where it can innovate and test and go to other markets without losing its strength. So this brand has like a credit with the general public so that it can go to new categories, new arenas, new markets, reducing its risk, not only in its portfolio of origin and also by augmenting its portfolio. And due to loyalty or the strength that the brand has in the business itself, we say that the brand is an asset of the business that becomes lively due to contact points. It's the product you use, a service I use, then the brand is more alive. And if we can manage these contact points with the asset, we can create identification, differentiation, and create also value. And this means that a high famous brand generates an asset to create value in other arenas. When we look at Apple, the more it is able to use this margin of innovation that it had because of its strength in other arenas, then its value grows and grows even more. But what does this mean? Mainly when we talk about protection. What is a brand that is not in its traditional economical group anymore, in what we had already mapped, and starts entering in other arenas, like Megan said about Samsung making lipstick. Was it what you said? So this game of competition is more and more strange in places we did not envision. Apple is not doing that and also increasing its value. What does it mean to expand to a different arena? When I leave my predefined category, especially in branding, when we talk about category, we are talking about brands that compete with the same time and money. We are the consumers. We have 24 hours per day and a salary at the end of the month. They address the same wishes and needs, offering the same kinds of products and services. So you understand protection per class because you know the kind of offer that brand is going to give you. But when you expand to other arenas, this is not for the future. The brands that are in our ranking, that are part of that volume, they do that already. They start competing for the same people with the same salary, but they address different needs and wishes through different products and services. When we talk about Samsung, it's an example, and also Apple. We cannot define Apple in a fixed category. It is in health, it is in payment, technology, it is expanding more and more. So the question for us to think about is how can we expand the protection to this freedom of expansion and new opportunities that the brands have to transcend their own original category. Now, how do we read or evaluate in our brand valuation? We have 3 items that we map to get to the value of the brand. We start by a financial analysis. That's the first step. Financial analysis is to identify what is the potential of generating money that the business has or the brand has. After we have all these points here, we have the economic profit, and then we analyze it financially. The ranking is open, so we use portals like Bloomberg. When we have an ad hoc project for a specific brand and it needn't be listed, we use internal data because it's a direct negotiation with the client. I would like you to remember this graphic because it's going to become even more important. So first we do the financial analysis. What are the business demonstrations? Then we have to understand the role of a brand. The name, like Hermes, this name is a bigger or a lesser influence when the consumer is going to buy the product or a service. Depending on the profile or the public, we have differences. The role of the brand is higher when we are in brands that have an emotional relationship with the consumer, and it is lower when it is a functional relationship. When we talk about luxury market, you buy Birkin Hermes because it's a very specific brand. This is emotional. But if you have a functional service, the role of the brand in the decision-making process is lower. It's not emotional. This means that when we start to map and understand how is the sum of the final value of the brand? It's like a disaster check. What is the average of the role of that economic group vis-a-vis the brand we are mapping? For instance, and we go back to categories. It's like a disaster check. When we see the first one, the first one is luxury. In the luxury category, 67% of the value of the brand has to do with the role the brand has on the value. If I'm mapping a luxury map, but it is higher or lower than 67%, or I have to review, either I have to review my analysis, or I will understand that that brand has done a disruption within its category. Apple is an example. The role of the brand is more than the traditional mapping of the category. Now we identify what is the percentage of the role of the brand in this potential of generating money for the brand when we put it here within the projection of revenue. We have the economic profit, and then we have this first cut. All this economic profit, N% is over the role the brand has in generating money. And the last item is the strength of the brand. The strength of the brand is done about strengths and weaknesses, internal and external factors to the brand. In internal factors, we have direction, alignment, empathy, and agility. External factors that are outside the walls of the brand: distinction, coherence, participation, presence, reliability, and affinity. I would like to talk about distinction. When we talk about protection and registering a trademark in the INPI, we are talking about its distinctiveness. This enters here when we are mapping what are the weak and the strength points. When we understand the attributes of a brand, what is more or less, we have a discount tax that we take away from the financial profit. We call it risk index. The stronger the brand, the smaller its risk factor, and vice versa. And here we are looking at the future, to the perpetuity of the brand. And by summing up those three items, we arrive at the value of a brand. That's what I had to say. Thank you very much for your attention and for the opportunity. If you want to know a bit more, you can talk to me.
Anne, muito obrigada.
Thank you very much, Anne. It was very interesting presentation. It's very exciting to hear a different point of view from what we are used to. And I think that everybody could have the same idea how your two presentations were integrated in terms of how the companies today are going beyond their original activities. This is a trend. So one consequence of that, and one of the conclusions we may get to, is that it's more and more important to try to obtain the protection of the famous brand in the US through actions that dispute dilution, or in Brazil through the INPI. I think this was very clear legally as well as economically. Thank you very much for your contributions. And I'd like to open now for questions.
Barbara. Hi, Barbara. My question is actually to Megan. So you were talking about the Meta Birkin's decision. I want to know, like, if you feel that the courts will keep that trend going. And my question is, like, I'm a brand protection manager, like I'm a global brand strategy myself, right? And since that decision, I have this sense that the clients are feeling more safer, in a sense of that's okay, we should take a step back, not file my trademark in that specific class, this and that. So my question will be if you think the trend will keep going, or if we should keep our seatbelts fastened and expect more stuff. Thanks. Oh, great lecture, by the way.
Thank you so much for the question. I think that's a great point. And one of the things that I was just hearing from some examiners at the USPTO is that the Trademark Office has been flooded with applications for classes that would be focused on NFTs and the metaverse. So it was sort of like thinking all of a sudden, we all have to file, you may sell hamburgers, but you have to also file in 9 and 20. Exactly. And I think that hype cycle is over, and I think companies are feeling much better and will not be making those filings. I think those classes are going to be a disaster, because it's going to be really hard to weed out what is real from what is not. And I think it's created an administrative mess. But 2 years ago, we were all advising clients, well, you better, just to cover your bases, you really should do that. So I think in that kind of, the pendulum swung far to one end, and now I think we're starting to take a much more reasonable approach. And I suspect that same thing is going to happen. The Meta Birkin's case is an example of that as well. I'm curious if you agree, or if what you predict.
I agree, but the U.S. things are always, it's always a roller coaster kind of thing. So I always say we can take a step back, but we can pay some attention. Mm-hmm. Yeah. But I do like the decision. I appreciate it.
Yes, it's sort of cautiously optimistic.
Yes, always. We're as a lawyers, we need to be cautiously optimistic. Always.
Great.
Thank you.
Thank you.
Temos mais perguntas na plateia?
More questions from the audience?
Bom, enquanto...
So while we are not having more questions, I have a provocation/question to Anne about what she commented about the data being published, because this seems to be a very sensitive issue, legally speaking, here in Brazil, when we have to seek protection on the Institute of INPI. We have to demonstrate confidential information many times, and the clients are reluctant to provide us with this information. So we try to encourage them, showing the benefits of the recognition of the fame can be good for the company, and try to do it in a balanced way so that it doesn't become a problem to the institutions. You said this is a problem in terms of valuing the brand, because in general, you cannot do the complete work if you don't have this information. In those cases you mentioned about Brazil, do you see a difficulty you talked about the difficulty of classifying them. How do you approach the client? How do you deal with this delicate situation? It's a very frequent question we have when people come to us about brand valuation or strength of the brand. These are two separate issues. When we are mapping for the rank, we have to use the data that are open and published. This is important so that we don't have any bias. We have specific areas that use those financial data to do the first part I said, which is the financial reading. If you don't have this published, the brand will not be able to apply to the rank because we won't get into contact, because if we do, the data provided are selected. So we won't have control if what we see is what everybody else is seeing, or it's just the narrative that the brand is building on itself. So everything that goes to the rank has to be public, plus quantify and qualitative research that we do directly with the consumers. The research institute goes to the consumers, map, regardless of categories, and we use all this information to establish the value. When we read about brand valuation in an ad hoc project, then yes, we can have an open reading with the internal data that the brand gives us, but we never publish them. So it's nice that everybody have. Yes, we would have a sample. The Nubank is a very strong brand, but we didn't have the data. It would be nice to have data from everybody, but I think it's difficult. We have to ask people, and they have to select what data to give us. Thank you for your question anyway. I guess we are coming to the end of our time. Last opportunity for questions. Thank you. I have a question to Megan. I'll speak in Portuguese. I just want to talk about the protection of the highly famous brand in Brazil. When the Brazilian law was published, the idea was that we use the same system as the US, meaning that the courts would be able to recognize this famous brand, and there would be no need for the institute, the INPI in Brazil, to recognize that. Initially, when the law was published, if you consider Article 125, the idea was to use the American experience to bring this case-by-case protection if there was an incident. But there was an evolution. There was a case law presented in Brazil, and then the decision was taken saying that it is necessary that the Brazilian Institute, INPI, recognizes it. My question is, the USPTO, when they recognize, can they recognize in a concrete case and then establish that this is because of the brand is famous? The question is, can they do that? Can the USPTO reject a brand based on fame or well-known brand or famous trademarks? And this decision, does it reflect outside? I mean, can the holder of the brand use this decision in other cases?
Thank you for your question. I would answer it in two ways. So I think that the USPTO can be somewhat contradictory in the approach, and it's possible to reconcile, but I see it going in two directions. One, under the likelihood of confusion analysis in the DuPont factors, the USPTO can use fame of a pre-existing mark to prevent registration of a junior user. And the more famous the mark is, I think the significantly stronger that weight the mark will hold with the PTO. On the other hand, as we were talking about earlier, the TTAB, kind of the judicial arm of the administrative body, has said that well-known marks doctrine is no basis, categorically no basis for opposition or cancellation. So I see it kind of two directions, and perhaps it's not inconsistent, but it feels like it needs a resolution.
Bom, gente, muito obrigada.
Well, we are running out of time. The subject was very interesting. I couldn't keep the time because I am interested, and also the audience was very much interested. So thank you very much. Thank you, Megan, for your presentation, for your time, for coming to Rio. Thank you, Anne. Thank you. The economic view is very interesting. And that's it. Of course, other questions you can send by email, and we will give them to the presenters. Thank you very much.